Started. Okay, good afternoon. Thank you for joining us. My name is Allison Carabin, and I work for Jewish Residential Services, a nonprofit organization that serves adults with psychiatric, intellectual, and developmental disabilities. The JRS Supported Living Program works with adults with chronic and persistent mental illness and or developmental disabilities living in their own homes who would like to become more independent or improve the quality of their lives. The Sally and Howard Levin Clubhouse is a licensed psychiatric and social rehabilitation program that works on the Clubhouse International model and is centered on a work-ordered day. I work with the Families in Transition program, and that includes 2 culturally Jewish community living arrangements that we have created with Verland and are operated by Verland, information and support to families and free educational programs for our clients, their families, and the greater community, such as this. Before I introduce our presenters, I just have a couple housekeeping issues. First off, the program is being captioned, so you can turn on or off your captioning at the bottom of your screen. You have to click on mine, it's the More and Show Subtitle will get you the captioning. Second, we'd appreciate it if you could keep yourself muted, just because there's a lot of us and it gets difficult when we have a lot of people with background noise. If you have questions, I encourage you to write them in the chat and the speakers will go over those when they're done with their presentations. Lastly, we are recording this program, so if you have to leave early for some reason, you can catch up with us. We will post it on our website and we'll share a link with everyone who participated. But if you don't want to be seen, or if you don't want to be seen, now is a good time to turn your camera off. But we like to keep this informal, and if you feel like having your camera on, we would love to see your faces. I'm very excited about this program. We have 2 very knowledgeable speakers. Gerri Sperling is an attorney at Strassburger, McKenna, Gutnik, and Gefsky, and she's going to outline the basics of guardianship in Pennsylvania. And Elysia Mancini-Duerr, a staff attorney at Disability Rights Pennsylvania, will speak about alternatives to guardianship. So it should be a really interesting program, and I encourage you to save your questions to the end. For reporting purposes, we would like for reporting purposes, I had a poll that isn't working, I think because there's 2 of us signed on my account, but it was asking how many people on the chat, on the program are here that have, you know what, sorry, we're trying to figure out the breakdown between people with intellectual and developmental disabilities and mental health issues. But I'll figure out how to get that information from you afterwards. Sorry for the delay, and I'm going to turn it over to Gerri.
Hi, everybody. My presentation is really Guardianship Law 101 in Pennsylvania. As an attorney, I started doing guardianship work, probably 20, 25 years ago as an adjunct to other types of orphans court practice. And orphans court is the court in any county you're in that hears guardianships. And at first it became, guardianship. Well, I have my grandson and he's for the school district. I need something to show that I'm his guardian. But my practice has really evolved to people coming to me who want to obtain guardianships over family members or believe that close friends or family members need a guardian, or are individuals for whom guardianships are being sought, and they don't think they need a guardian. So I've learned guardianship from all sides, and it's not an easy one-size-all proposition in Pennsylvania or anywhere. So the first question is, what is guardianship? Guardianship is a legal proceeding to appoint either an individual or an organization to make decisions on behalf of an adult who has been determined by a court to be an incapacitated person. And the term that is used today in Pennsylvania is incapacitated. The test is a test of capacity. People use the term competency or incompetent, but those words don't mean anything in Pennsylvania for the purposes of a guardianship. So what does the term incapacitated person mean? Well, the Pennsylvania guardianship statute itself has a definition. An incapacitated person is an adult whose ability to receive and evaluate information effectively and then communicate decisions in any way is impaired to such a significant extent that they are partially or totally unable to manage their financial resources or meet essential requirements for their physical health and safety. So it's the ability to receive information, evaluate information, and communicate decisions. The finding of an incapacity by a court has to be supported by expert evidence as to the individual's ability to receive and evaluate information effectively and to communicate decisions. And the type of testimony or evidence that is required by a court is the expert opinion of a psychologist, a neuropsychologist, a geriatrician, a psychiatrist, or another type of medical doctor. A layperson's opinion as to capacity has no merit. And throughout this, as my presentation, I get very uncomfortable using the term alleged incapacitated person. That's the term that the statute uses. That's the term that lawyers use. I'm going to try really hard not to use that term, but I'm going to have to slip into that a little bit. But at least I wanted to make sure you understand what we're talking about in terms of capacity or incapacity. So what does all this mean in real life? The Pennsylvania Guardianship Law recognizes, it's even in the statute, every individual has unique needs and differing abilities. The purpose of the Guardianship Law, as set forth in the statute, is to establish a system where incapacitated individuals can participate as fully as possible in all decisions that affect them. These objectives can be accomplished through finding the least restrictive alternative for the individual who is the subject of the guardianship proceeding. And that too is actually in the law itself. You need to look to the least restrictive alternative. So what does that mean? What is the least restrictive alternative? Sometimes the least restrictive alternative isn't a guardianship. Sometimes an individual has the ability, still has the capacity to delegate decision-making authority through a power of attorney or other type of advance directive. And I know that's some of what Elysia is going to be discussing later. But in that instance, the person still has to have the capacity to understand what they're doing, to understand what they're signing. The document that they're signing is going to delegate authority in the event that they need assistance, but they still have to be able to understand that. You know, one of the first guardianship cases I consulted on, a family came to me and their son, who had severe intellectual and developmental disabilities, had just turned 18 and couldn't read or write, and they wanted to apply for a passport for him. But they wanted him to apply. They didn't want to go through a guardianship proceeding. So they wanted him to sign a power of attorney He didn't know how to read or write or sign his name or what a power of attorney meant. And they came to me and said, well, can't you just prepare one and we'll hold his hand and guide it so he can sign his name? And I said, no, I can't do that. I won't do that. That violates my ethical obligation. And the whole purpose of a power of attorney, as I think Elysia is going to be explaining later, you have to understand what you're doing when you delegate that authority. And that was the kind of situation when I'm describing where guardianship really made sense so that the parents could make decisions and take actions on behalf of their son. Another example recently that I've been working on is two siblings who obtained a power of attorney from an elderly parent. The parent suffering from dementia and had a stroke. And there is serious question as to capacity. The siblings are using the power of attorney to use the parent's assets, not necessarily in a way the parent would have wanted those assets to be used. So again, there's a serious question as to whether that parent had the capacity to enter into the power of attorney at the time. And that is being challenged in court right now. So when you do use alternatives to guardianship, you want to make sure that they make sense and are right for the situation. But even if a guardianship is warranted, courts work to tailor them to be as least restrictive as possible with the goal of protecting the incapacitated person. This is all about protecting the alleged incapacitated person, not burdening them or restricting them too much in ways that are unwieldy and unfair. One way of tailoring a guardianship is the use of partial guardianships. And in a partial guardianship, the individual who's the subject of the guardianship is still allowed some authority to make decisions on their behalf. For example, they can decide perhaps the guardianship order is very tailored. It will specify that the guardian is appointed, a guardian of the person is appointed over that individual to make decisions about their medical treatment, for example, and to consent to medical treatment. But the individual can still decide where they want to live, who they want to live with. That's an example of way a guardianship order can be tailored. And I mentioned guardian of the person. There are two types of guardianships. There's guardianship of the person and guardianship of the estate. Guardianship of the estate gives a person or frequently some kind of financial entity the power to make financial decisions, could enter into contracts and leases on behalf of the individual and amass and preserve and invest the person's assets. That guardian has what's called a fiduciary duty to the individual to make sure that their assets are being protected and spent in their best interests. Guardian of the person is exactly what it sounds. It's someone who has the legal authority to make personal decisions on behalf of the individual, where a person lives, who they live with, medical treatment, and general other financial matters. So what's the legal process? How does this work? Any interested person can file a petition with the court, with the orphans court in the county in which the individual resides to seek the appointment of a guardian for the alleged incapacitated person. The orphans court gets this petition, looks it over, makes sure everything that needs to be there is in there, and then schedules a hearing and issues what's called a citation. The citation has to be served on the person who's the subject of the guardianship proceeding. And service doesn't mean send it to them in the mail or drop it off at their house. Service means that you actually have to give it to the the person who's the subject of the guardianship, read it to them, ask them if they understand it, leave it with them. And that document will tell them when the hearing is going to occur, what time, where, and what their rights are. And one of their rights is to be represented by counsel at the guardianship hearing. If they can't afford an attorney, don't have an attorney, the court will appoint an attorney for them. There are also cases where courts, not in addition to appointing an attorney or instead of appointing an attorney, will appoint what's called a guardian ad litem, which is an individual who will represent the interests of the subject of the guardianship to in that proceeding and to make a recommendation to the court. What does a court consider in determining whether to appoint a guardian? In all guardianship cases, the orphans court is supposed to make specific findings of fact regarding the following. First, the nature of the condition or disability which impairs the individual's capacity to make or communicate decisions. And secondly, to the extent of that incapacity. And once those two findings are made, whether there is a need for guardianship services in light of such factors as the availability of family and friends to assist the individual, and in light of the existence, if any, of any advance directives. And then the court is going to determine what type of guardianship is necessary. Is it a limited or partial guardianship? Those terms mean the same, as opposed to a full or plenary guardianship. Also, is this going to be a temporary guardianship? Is it a capacity that might be temporary in nature, or is this going to be a permanent guardianship? But even if it's a permanent guardianship, a party can petition for review at any time and present evidence of a change in capacity or status. It's important to note when you're looking into guardianships that the guardianship law itself states that the court shall prefer a limited guardianship. That means unless the court finds somebody is totally, completely incapacitated, some authority, some decision-making authority will remain with the individual. Guardianship should be the last resort to protect an individual and not to further any other party's interests. Guardianship can be avoided through good estate planning, through use of trust documents, through powers of attorney, so long, again, that these documents are entered into before an individual actually is unable to have the capacity to sign these documents. There are always cases that come up where there is no other alternative, but the important thing for everyone's sake is to explore what other alternatives are available. So does anyone have any questions? One thing I skipped in Guardianship 101, who can be a guardian?
Feel free to write your questions in the chat or unmute yourself.
Yeah. One thing I am going to say in terms of who can be a guardian is that anyone can be a guardian, but you have to submit certain criminal record checks. And for financial guardians, you may have to post a bond. And I saw there was just a question popping up in the chat but I'm having trouble reading the chat. So could you read?
I'll read it to you.
Thank you.
The question is, why would the Orphans Court choose/appoint an agency like Jewish Family and Community Services as guardian instead of a capable and free interested relative?
Well, first of all, sometimes there aren't capable and free relatives. I'm working on a guardianship right now where there is nobody. There is no family member who is willing to serve in that capacity. And secondly, if the court is concerned about the family member acting in the best interests of the individual, it makes sense to go to a neutral third party. I've been involved in some very ugly, messy, horrific guardianships where family members, meaning the best, had very different viewpoints as to what was in the best interests of the person. And it really took a third party, more than one case actually, where it has taken outside objective third parties to come in who will actually really listen to the person, the subject of the guardianship, rather than family members who have their own worldview and their own, whether it's intentional or not, agenda.
Okay, we have a few more questions. The next one is, can only one person be a guardian or can it be two people?
You can have co-guardians of the person, co-guardians of the estate. I've seen that work out really well, but you want to make sure people get along. And the court can always remove someone or remove both if there's a problem.
Yeah, and I'd like to just chime in on my side of the state in Philadelphia. There's a judge that won't, the law allows co-guardians, but some judges don't like them, right? So like if there's a judge, his name's Carafulo, he just won't issue co-guardianships because he's seen too many of them come back when they disagree. So much of it's in the hand of whatever judge, like all the judges are so different.
And most of my practice is in Allegheny County. There are 3 judges right now. I've never had an issue with co-guardians. Also Butler County and Beaver County, Westmoreland County, where I've handled guardianships, that they appoint co-guardians, but I could see where it could end up being a conflict. And also with regard to guardian of the estate, sometimes they'll appoint a corporate entity and an individual, and that could be setting up conflict too, but they're doing that here.
Okay, we have 3 more questions in the chat, and I want to be sensitive to the time, but I will, if everyone can hold the rest of their questions for Gerri to the end. Someone asks, does the incapacitated individual have to appear and answer questions in the hearing?
That is a great question. So the incapacitated person, if they are in the Commonwealth of Pennsylvania and in the counts, they're supposed to appear unless it would be detrimental to them to appear. And you need something from a physician or some other professional to explain why it would be detrimental to them to appear. In the time of COVID until next week, my guardianships have been remote and people participated remotely and have appeared. But I have had guardianships where the incapacitated person was too incapacitated to appear.
Okay. A question referring back to the example you gave.
Which?
How did the parents get the passport? Or did he not get a passport?
We did a guardianship.
Okay. And,
I don't know if he got the passport. We did a guardianship.
Okay. The last one is, I was guardian of the person for my mom who had dementia. There was a third party who was the guardian of the estate and handled money and finances. Due to we as siblings wanted a third party to take on that responsibility. I think they're just sharing their experience, which is one way to do it.
Right.
Yeah, thank you.
That's a good way to do it too, because it protects you and your siblings from any claim that anybody could make that you were somehow or other not using your mother's assets appropriately. So, okay.
Great. The last comment is thank you. And there's a couple thank yous. I want to thank you, Gerri. This was very interesting. And now I'm going to turn it over to Elysia, who is going to talk about alternatives to guardianship. You're on mute, Elysia.
Okay. I'm trying to successfully share my screen. Can you see my slides?
We can see your slides and we can hear your voice.
So good. So here I am. My name's Elysia. This is my phone number. If you want it, you can write it down. You can feel free to call me if you have a specific question about your specific family. Like that's probably usually preferred to asking in front of a big crowd. But my name is Elysia Mancini. I work for a protection and advocacy organization called Disability Rights Pennsylvania. There's one in every state. We're actually given powers by the federal government to help people with disabilities. It's kind of cool. We actually have like power to do things like go in without a warrant and search the premises of a nursing home if necessary. But my role is to represent people who are alleged incapacitated in hearings and protect their right to less restrictive alternatives to guardianship, which Gerri already mentioned. She did say that the law requires that if there is a less restrictive alternative to guardianship, it has to be explored. And there are a lot of alternatives to guardianship. Some like lawyers don't even know about, some the court doesn't know about. So, it's my role, even when my clients are incapacitated, to make sure that their right to not have a guardian unless all the alternatives have been explored and exhausted. That's what I do. And this is a list of alternatives. We'll go over each of them. Gerri, I don't have on this list, and Gerri mentioned it, but I do think it's important to note that limited guardianships, I consider to be an alternative to guardianship, right? Because that's what the law prefers. And the law says it always prefers limited guardianships. And Gerri already mentioned that. So like, for example, I have a client right now who, guardianships can be limited in time or they can be limited in scope. And she can make most decisions, but she doesn't have the capacity to engage in this complicated real estate transaction. She has to sell some property that she inherited. So we're asking for example, what was petitioned for was a plenary guardianship, and I'm countering by saying she just needs a limited guardian for the sole purpose of selling this property. And once this property is sold, she'll no longer need a guardian. And it's those kinds of arguments where we're saying, because you're still preserving that person's freedom as much as possible, but there are some things some people can't do, and they might need a guardian. And so I do consider limited guardianships to be an alternative to guardianship. The first one we're going to talk about is supported decision-making. Gerri mentioned that one of the things that it says in the statute is the statute requires people to consider the availability of family and friends when petitioning for guardianship. And supported decision-making is just the idea that some people just need support from others when making a decision, right? Sometimes you hear a lot of talk about it now, and some states are turning this into law, they're codifying it. I don't think it needs to be codified, because all it is the very simple concept that people need to consult with other people when making a decision. And we all do it, right? I do it. Hopefully you all do it. Everyone does it unless they're a hermit. So it's just someone with a developmental disability might need more support than like you or I. That means they might need to talk to more people, and they might need to take more time. But it's preserving that person's right to get support from other people, but ultimately they're the one making the decision. And that's all supported decision-making is. Now, there is no law in Pennsylvania that expressly recognizes supported decision like there is in other states, but it does exist in what's called case law, meaning there was a case that went all the way up to the Supreme Court of Pennsylvania and set precedent, and it's called in R.E. Peary. And in that case, there was a woman with a developmental disability whose brother applied for guardianship for her, and she had support, right? She had like a supports coordinator and a social worker and all these services. And the court ultimately concluded that because she had so much support, she didn't need a guardian. And kind of what it said in a lot of words is that if you took this person alone and looked at them like in a bubble, maybe they would need a guardian, but she wasn't living in a bubble. She had what they called a circle of support. She had other people helping her. And because of that, it's as if she was not even really incapacitated. So alone people can be considered incapacitated, but when you look at their circle of support and their family and friends, and this is the only really case like this, but it referred to the statute that Gerri referred to, where it says you have to look at available friends and family. That's the law that this case was referring to. That's really an alternative to guardianship. Now there's limits to that, right? So it doesn't work if you have a person who refuses assistance. And, we know that there's some people like that. It doesn't work if there's another legally recognized substitute decision maker. So a guardian is a substitute decision maker. It's not a supported decision maker, someone else making decisions for them. It doesn't work if the person can't communicate. It doesn't work for people with like very low capacity who can't communicate what they think and believe, right? Because this is about helping people make their own decisions with support. So the person has to have at least enough capacity to be able to communicate their decisions and to like process the information and come to their own decision, even if it takes them longer and like they need a lot of help. There are some decisions that require informed consent. And it won't work for that. Like there are some healthcare decisions where the doctor or a surgeon insists on having like a legal substitute decision maker for their own liability reasons. They say like, I'm comfortable getting consent from this person because I don't feel like they have the capacity to consent. It doesn't work in these cases, but there's another alternative to guardianship I'm going to talk about in a little while called a healthcare representative that can work really well in tandem with this, where you can have someone make most decisions with support, and then medical decisions that they can't make themselves can be made by someone that's called a healthcare representative. And I'll go over that in a few slides. So Gerri already talked about agency, like, someone signing over agency to someone else, like a power of attorney. A healthcare power of attorney is actually called a Healthcare Advance Directive. And if someone has the capacity to sign that, they can sign it, as Gerri already explained. I'm probably more liberal with this than most people because I work for a disability rights organization and we always support people's right to make their own decisions. So like from my point of view, even if someone can't read and they can't write, if they understand, like if it can be explained to them in terms that they can truly understand, I feel that they can sign an advance directive. There's a really simple advance directive that we provide for our consumers that has pictures. It meets the legal requirements in Pennsylvania in terms of what, like the law lists like what should be in a healthcare advance directive. It has everything, but it's like very simple and it has pictures and the language is very simple. And like that's the kind of healthcare advance directive I would use for someone with a developmental disability. Again, they still have to understand it, but even if that means I have to read it to them, if they can't understand it, then no, they should not sign it. There is a state law that it has to conform to. And if anyone wants a copy of this healthcare advance directive, I could share it with you. So again, this is just going over who can do, like who can sign it. If they understand it, they can sign it. And if they're of sound mind, which to me means they can understand it. They have to be 18. And I like healthcare advance directives because the medical community understands them. Like it's very clear, like they know what they are. You show that to a doctor or a hospital, everyone has, like they get it, right? And they can choose someone else to make the decisions for them, or they can choose someone else to make the decisions for them once they no longer understand. There's two different ways it could be executed. But either way, so like a lot of times parents of adult children with developmental disabilities want to have the kind of healthcare advance directive that kicks in immediately, like as soon as it's signed, not the kind that will kick in someday in the future if their child someday doesn't understand. It just gives the parents a little bit more ability to make decisions for their child. Okay, so the thing I'm talking about now is probably the least used alternative to guardianship in the Commonwealth, I think. And it's a healthcare representative. So it's in the law. It's in a different chapter than the guardianship chapter. It's in chapter 54. Guardianship law is in chapter 55. And the exact place where it is 5461. It's called Act 169 because that's the legislative act that kicked it into place. It's pretty old by now. I mean, it's been law since like 2006, but for whatever reason, it hasn't like taken off. So a big part of my job at Disability Rights Pennsylvania is to educate people about this law, because it's a really good alternative to guardianship. It's free, it doesn't cost anything, it's legal. And we were actually given a grant by the state to talk about this. So this is kind of why I'm here. So basically, this law does use the word incompetent, not incapacitated. So it uses a different word than is used in the guardianship law. But it says that there's someone who becomes created who's called a healthcare representative when a physician deems the patient as incompetent. And if the physician thinks the person is incompetent and can't consent to like a medical procedure, someone can miraculously just become a healthcare representative. They don't have to do anything. They don't have to go to court. They don't have to sign any papers. They just are. So, and it only works if someone's 18, which is on the slide. They already don't have a guardian and they already don't have a power of attorney or a healthcare advance directive. Okay, so I'm jumping ahead, but these are the people who can be healthcare representatives, and they're articulated in the statute. And the way the statute reads is, if a person's incompetent, these are the people that can make decisions for them, healthcare decisions, in this order. And like the people in this order, the first people have to be not available or not existent for the next person on the list to kick in. So the first person would be spouse. So that would obviously apply if someone like their spouse or their loved one has dementia or, some degenerative illness that renders them incapacitated or incompetent. Then adult children, again, that would be for parents. Parents, that would be for parents of adult children who are incompetent, adult siblings, grandchildren. And then there's a catch-all in the statute that says anyone who knows the person, right? So that could be a friend, that could be like a nephew, a niece. It can be really anyone except the person's healthcare provider. And they can make healthcare decisions, right? So this works really well with supported decision-making. And like, let's say you have a person who understands most things and kind of make decisions, but they need help. But then the surgeon's like, I don't feel comfortable authorizing this surgery because I don't think this person's competent. And the parents, let's say it's parents of an adult child with a developmental disability. And then they go to Gerri and they say, Gerri, can she sign a power of attorney? And Gerri says, no, because I don't think she understands it or whatever. Then the parents are healthcare representatives and they can make the healthcare decision for their adult child, be it a surgery or dental procedure or whatever. And there are limits. There's certain things healthcare representatives can't do. And this is, in the statute, they can't refuse life-preserving treatment. Neither can a guardian. And then there's like a kind of a presumption in the legal community that knows about this, that they probably can't do, like if a guardian can't do it, they probably can't either, right? It doesn't really say that in the statute, but I think that reasoning is sound, right? There's certain things guardians are not allowed to do. They're listed here, like for example, like in Chapter 55, that's the Guardian Law, 5521F, guardians cannot commit their wards to a psychiatric facility. I'm mentioning that because Allison's made it sound like maybe there's people here who have loved ones with a mental health diagnosis, right? Guardians can't do that. They can't, if you want to be a guardian to put your loved one in a psychiatric facility, you can't do that anyway. It's against the law. So that's like not going to work, but we think probably healthcare representatives can't do that either. But other medical decisions, healthcare representatives can make. And this is really underutilized. Like I said, it's a really convenient alternative to guardianship. You don't need any paperwork to be a healthcare representative. But what the statute says is that if the healthcare provider asks for it, you have to provide them with a declaration. And we think, and it looks something like this, like what I have on the screen. And what we think a declaration is for is to kind of protect the healthcare provider, right? Because we know there's laws like HIPAA and they can't just be giving healthcare information to any old person. So by them having that healthcare declaration on file that you as the healthcare representative sign, now the onus is on you if you're lying and you don't really have the legal authority to make healthcare decisions for your loved one. It's not on the healthcare provider. So we have an example of a healthcare declaration at disabilityrights.org. There's a section called resources, and there's a whole section on guardianship. And in that, we have a sample healthcare representative declaration. We have a little pamphlet that explains about this law. And like, we encourage you, if you have a loved one who you're thinking of getting guardianship just so you can make medical decisions, if that's the only reason, we encourage you to try to use this first and to try to make a healthcare representative declaration, because that's really what this law was designed for. And it was designed to help families, make it easier for them. And it's just not being used. So it's like a rich resource that's there for the taking, and nobody's using it. So now I'm going to move on to, I don't know if anyone has a question about that before I move on, or because that's really like, if you get anything out of anything I say, I hope it's that part of the healthcare representative declaration.
I'd like to say something. I was so excited when you pointed this out to me because I wasn't familiar with it. And I can't wait until I have the opportunity to do this with a client. I'm just hoping that Western, because I don't think this is used in Western Pennsylvania, we may end up having to fight a little bit with UPMC's legal department and Allegheny Health Network's legal department to show them this law and show them why this works, because this is very exciting and I don't think anyone's doing this here.
Yeah, I mean, it's not utilized out where I am that much either. We just started like 3 years ago trying to push it out in Eastern Pennsylvania. And sometimes what we tell people when they call our intake line is go to your healthcare provider with the printout of our publication and the healthcare declaration. And then if they have a problem, they can call us. And sometimes they do call us. Doctors will call us and they'll say, is this legal? Like, is this really okay? Because that's what they care about, right? They don't want to get in trouble. They don't want to get sued. They care about their liability. They don't really, like, doctors are telling people they need to become guardians, but they don't know the law. They're not lawyers, and they shouldn't be telling anyone that, right? But when they're telling you that, they're not telling you that because they really want you to be a guardian. They're telling you that because they want to treat your loved one without liability for themselves. So when I tell them, yes, this is legal, you know, come back on us. We have malpractice insurance. Like, if you get in trouble, you're not going to get in trouble. That's what they want to know, that they're not going to get in trouble. So the issue with healthcare representatives come when someone has, I don't think I have this in the slide. No, but the issue comes when someone, let's say, has like borderline capacity. And like, let's say they disagree with the healthcare representative. Like, let's say the mother, you know, you're a mom and your child has developmental disability and you're like, I want them to get whatever, this surgery. And they're like, no. Then if the doctor isn't like 100% comfortable with the fact the person's incompetent, then you probably should go to court and have the judge figure out like a guardianship, you know, because then it does become a legal thing of, is this person incompetent or not? I'm not sure. They're saying no when the mom is saying yes. Maybe they understand more than we're giving them credit for. And that's maybe when but a court intervention would be necessary. But like in 9 times out of 10 of the cases I do, there's no question that the person's incompetent or incapacitated at all. And it's very clear that someone else needs to make the decision for them. It's just, do they need to be a guardian, or can they get by on just being a healthcare representative? But yeah, there can be questions. So sometimes you do have to go to court if there's like a question like, are they incompetent or not? Are they incapacitated or not? Sorry, I hope that wasn't too much information.
No, we have a couple questions if you want to take a break for questions, or do you want to continue on?
Yeah, I can take it. Are they mostly related to healthcare representatives?
The question is, how can guardianship or alternatives protect an individual should they be involved in or charged with a criminal act, especially when they don't understand the act?
Okay, I have that. That's my last slide. So we'll get to that one.
Okay. And I think there's one person, Ellen Byrne. Yeah. I don't know if you're there. If you want to unmute yourself, you can ask a question.
I am on mute. I think, can you hear me?
Yes.
Okay. The form that you have up right now, the healthcare representative, is that something that has to be notarized by a notary?
No, in fact, you don't even need the form. That's the cool thing about it. Like, you can just say, like, I'm a healthcare representative, but because nobody knows what it is, you do need the form, but it doesn't even need to be notarized. It just needs to be signed. I mean, things look more official if they're notarized, so it's not going to hurt to get it notarized, but it's not like a power of attorney don't have to be notarized either, right, Gerri? They just need to be signed by witnesses. But this doesn't even need to be signed by witnesses.
So if somebody has a healthcare power of attorney who they've listed, the first one, the second one, the third one, the fourth one, those are people who they would want to make decisions if they can't. Should they also have this healthcare representative declaration?
No, because healthcare, it says in the statute, healthcare representatives for people who are incompetent don't kick in if someone has a healthcare advance directive, which is a power of attorney. So it's like one or the other. But these are more for people who they never got the chance to execute an advance directive, also known as a power of attorney, and then they, or maybe they were always incompetent, or as Gerri likes to say, incapacitated. This statute actually does use the word incompetent. I don't like the word; it's kind of a degrading word, but that's what the statute. So, did that answer the question?
One more question from the chat. How expensive is it, or should it be, to take the P or psychiatrist mandatory deposition in order to get a guardianship ordered? And then he also says POAs must be notarized in Pennsylvania.
Yeah, I don't do a lot of POAs. But healthcare advance directives don't have to be notarized. So like a healthcare advance directive, we do at this, we don't do financial power of attorneys, but we do healthcare advance directives, and they don't need to be notarized. That's just for healthcare only. That has nothing to do with finances. They need to be witnessed.
Right. Just to clarify, there are different types of powers of attorney, and some deal with financial powers and some deal with healthcare powers. Financial powers of attorney, I do believe, do have to be notarized. But if we're talking about healthcare powers of attorney or living wills or other types of advanced medical directives, where you're designating an agent to make medical decisions on your behalf, they don't have to be notarized in Pennsylvania. It's good to have them notarized, but they don't have to be. They have to be witnessed, though. At a minimum, they have to be witnessed. What was the question about what does it cost to take a deposition for an expert in a guardianship? And you're going to hate this answer. It depends. I've dealt with experts who charge $300 an hour for deposition testimony. I've dealt with experts who you no longer need to have a deposition. You can just submit an expert report. And I've dealt with experts who prepared expert reports and haven't charged. So the answer is the very legalistic. It depends. And guardianships, when people ask me what it costs, my answer to that is it depends. It depends on how expensive it will be to get the expert. It depends on whether someone is going to contest it. It depends on whether someone is going to contest whoever you're proposing to be appointed guardian. So it's
all true. Yeah.
Not one size fits all.
To move on to the next question, if an individual is in crisis and the only place available for treatment is in a psychiatric hospital, what can the guardians do?
So I have this is like something you can give a whole presentation on, and I do have a whole presentation I've given on this. It could take a whole hour, but basically when someone's in crisis, they're like anyone else who's in crisis, and you have to 302 them. If you know what that means, it means you have to involuntarily commit them. There is no other, like guardians don't have a fast pass. They don't have a quick way to get someone who is refusing treatment into a psychiatric facility. The law is very clear that guardians cannot involuntarily commit their wards to psychiatric facilities. And so they just have to do what they would do if they weren't guardians, which is call 911 and have them 302'd, which is another reason I'm very much against guardianships for people with mental illness, because I feel like it's the least helpful. I think it's like worse than not being a guardian. And I can skip ahead to that, but I want to make sure I go back to this slide, but I'll go to my next slide a better alternative to guardianship for someone with a mental illness, in my opinion, is a mental health advance directive. And a mental health advance directive is like a power of attorney, we keep using that term, or like a healthcare advance directive, but it's specific to mental illness. And it has to be executed when the person is lucid. So like for most mental illnesses, they ebb and flow, right? Someone like with bipolar disorder might be sick sometimes, but then sometimes they might be well. Or if they have, schizoaffective disorder, any number of mental illnesses that come and go. When they're well, you want to really try to get them to execute a mental health advance directive. And they have to be 18, they can't have a guardianship, because now once you have a guardian, you can't make your own decisions anymore, and you can't be involuntarily committed. But if you're not currently involuntarily committed, you can execute one. And the good thing about a mental health advance directive, sorry, I'm going the wrong way, is that it can actually designate the person to make mental health decisions for the principal. So they would appoint an agent, just like they would appoint an agent for a financial power of attorney or an agent for a healthcare advance directive, to make those decisions for them, who can, under certain circumstances, commit the person, right? Like if it says, like, if I'm ever doing X, Y, or Z, my power of attorney can bring me to a facility. But without that paper, can't do it. Guardians can't do it. So this is like a much better alternative to guardianship for someone with a mental illness. And they're catered for people with mental illnesses, and that there's two parts. It's kind of like for a healthcare advance directive, there's two parts, right? There's like a living will part, which designates all the kinds of care you'd want if you were dying. And then there's the agent part, where you say, this is the person I want to make my decisions for me if I can't make them anymore. Mental health advance directive is the same way. There's a part called the declaration, where someone lists what they would want. That's very important, because people with mental illness, sometimes they've been through like a dozen medicines before they find the one that works. They can write down the medicines they don't like, where they prefer to be treated, if there's a mental hospital that they like more, a mental health hospital, all that kind of stuff, what they agree to, what they don't. And then there's an agency part where they can designate someone to make decisions for them if they're in a crisis. So this is like a way better alternative to guardianship, because guardians, like, their hands are totally tied, and like they can't do anything. So the one annoying thing about mental health advance directives is they have to be re-signed every 2 years. And I think that's, probably because people with mental health diagnoses, like, this stuff changes a lot. But other than that, that's a better alternative to guardianship. Sometimes I'm a court-appointed guardian for some people, and I've had problems where, like, even when they're trying to voluntarily sign themselves into a psychiatric facility, they can't. It's like a catch-22, because it's like, okay, well, they can't make their own decisions because they have a guardian, so they can't sign themselves in, but you can't sign them in either because you're their guardian, and it's illegal. So you have to 302 them. And it's just, for people with mental illnesses, guardianship is like a really bad option, I think.
There's one more question in the chat, if you
Sure.
have a minute. They ask, can you talk a bit more about how someone would define or determine sound mind?
Sound mind for way back when we were talking about the power of attorney?
I don't know. The question has been up for a while, so it might be.
Okay, so I'm gonna go back here. Sorry. Sound mind. Yeah, sound. So it means they can make an informed decision about the matters covered by the Advanced Healthcare Directive. So that's tough, right? Because some people can, but it takes a lot of explaining and like a lot of time and a lot of patience, and some can't. So it's like a tough call. Like I'm probably less cautious than Gerri in that I err more on the side of like, yes, I think they can understand, but I'm a disability rights attorney, right? So that's like my role, is to help people with their rights, and it can always be contested. right? But it's like, if I feel that they understand, if someone explains it to them in simple terms, they can understand the things that are on, because it's a form of agency, right? So agency law means like there's a principal, that's a person signing away their rights to someone else who's an agent and is making the decision for them. So if they really understand what they're signing away, they can sign the power of attorney or the Healthcare Advance Directive. If they don't, then they can't. And, sometimes you just have to use your own judgment, I guess, but, and you have to think about like, what you're comfortable with in terms of what you think they can understand. Because sometimes you'll ask people questions and be like, do you understand? And I'll say, yeah. Okay, do they or not? That's, but if there's already an here's the other thing. Like, so sometimes, if there's already an evaluation by a doctor or a psychiatrist or anything that says they're incapacitated, then it's like, at that point, you can't have a power of attorney or any kind of form of agency, because an expert is already saying, yeah, they don't have capacity to understand. They're not of sound mind. I don't know if that answered your question. That was like kind of like a vague answer, but I don't know how to answer it than to say you have to be comfortable with it. You have to really believe sincerely that they can understand the matters in the document, and that you should not have already had an expert say that they're incapacitated or that they can't understand, because then that would just be like outright fraud. But then you could be a healthcare representative, right? So
I had a question as far as, it's more broad. I work for JRS. How can we be more up to date on this kind of issue and really know what resources to give the people that are the people we serve?
Oh man, I don't know. I'm not sure. Have this kind of seminar. I mean, I don't know. It's hard to know, right? Because your clients, and like I can share with you the Healthcare Advance Directive I have, which is meant for people with developmental disabilities. Is that someone who you serve? And like you can look at it and you'll see like, oh, I bet a lot of my clients will understand this, because it's like done with pictures and stuff. But it meets the legal requirements for Pennsylvania. But not everyone's going to understand that. And then, what I find is like discouraging is when agencies, I'm not saying JRS specifically does this, but like when schools and doctors and agencies are telling people you need to be a guardian, like I would just discourage you from doing that. Like instead I would say like, you need to talk to a lawyer, because like that's I would just start with that instead of like giving out legal advice and telling people they need to become guardians. Say you need to talk to a lawyer and see if you need to become a guardian or if there's some other alternative that would work for you. I think starting right there is good, because a lot of people go to lawyers because a non-lawyer told them they needed to be a guardian and that scared them. And now they think, oh my God, I have to become a guardian. If not, I'm not going to be able to help my loved one. And, and then they go meet Gerri, and Gerri says, I think this person could sign a power of attorney. Obviously she's not going to lie about it. But, we shared and made that clear. Or they come to someone like me who says like, maybe you could try all these other weird things that no one thinks about.
Very thorough.
But I'm excited about this provision in the law that I don't know anybody doing here on for people who are quote unquote incompetent, but have family members who can be their personal health care representatives and not having to do. There could be other reasons, non-medical, non-health related, why maybe you need to have a guardianship, but that takes that out, assuming that I actually want to have a discussion with somebody in-house at one of the major hospital networks about this and set it up so that we know they'll accept it in advance, because most of the physicians here are part of these hospital networks, and they're going to go to running to the legal department the first time they see this.
It works really well when the person is compliant and obviously incapacitated. It doesn't work if there's a dispute or they're arguing with their care provider, or if, they're trying to run away, I mean, but for me, like I found like 9 times out of 10, it works because the person is obviously incapacitated and there's not a conflict.
And, Caitlin, in terms of answering your question about what JRS can do, you can do exactly what you're doing, which is being an advocate and an educator. And what I think is really clear from both what Elysia and I are saying is there's not a one size fits all to any of this. And we have to.
I think that's a really good summation of what you both said.
Yeah, and I feel like there isn't a one, like Gerri's saying, there's not a one size fits all answer for anyone. But when people hear from their doctor or their healthcare provider, you need to get a guardian, like that is a one size fits all. Like they're being told they need to become a guardian, and that might not be necessary. So it's like not, just telling people you need to really talk to a lawyer and not, so that the lawyer can go over with them what they need.
Have you sent any really easy to digestible documents?
Yeah, so we have, I gave one to Allison before the program. I think she can distribute it to you guys. It's like a 1-page alternatives to guardianship that we made. And on our website, disabilityrights.org, we have like documents, like we have a 3-page document about healthcare representatives. We have a 1-page document about alternatives to guardianship. We have lots of just easy things. And people can call us too for free. Like if they can't afford to pay for a lawyer consult, they can call Disability Rights Pennsylvania and they will get a consult. I mean, most of the staff are lawyers. They'll probably get me if it's a guardianship thing, and they can go over the specifics of their situation and get some free, like we won't do powers of attorney for people, but we can give you some just advice and you could take it or leave it. It's free. So I'm going to cover this real quickly. I don't think this applies to you guys because you guys are about keeping people in the community, right? But there is an interpretation of, DHS, Department of Health and Human Services, interprets the Healthcare Representative Act, the way I explained it to you, and other provisions in the mental health code to mean that if someone is in a facility for people with intellectual disabilities, or even living in the community in like a home run for people with intellectual disabilities, that if they have no other decision maker, that they're the executive director of that facility can make the decisions for them. And this is used very broadly. There's an organization called KenCrest. They use this all the time. It's part of their official policy. I have a petition pending in court where I'm saying this person doesn't need a guardian because she's in a facility for people with intellectual disabilities and the executive director can make decisions for her. And it's in the bulletin, which is like kind of like a supplement to the law. It's not the law itself, but it's their interpretation of the law. So for what that's worth, sometimes people worry, like, what happens when I die? Like, who's going to help my loved one? Well, if they're in a facility for people with ID or in a group home, like all is not lost. The executive director can make decisions for them. I already talked about mental health advance directives. It's a really good alternative to guardianship for people who have a mental illness. Okay, so now I'm going to switch and talk about finances. And if there's a lot of money, right, you might need some kind of limited guardianship, right? Or, the example Gerri gave of the parents, if parents have a stroke or something, and they never had a power of attorney drafted before that, and they own assets, that it's probably unavoidable. You're going to need some kind of guardianship. But if the person you're talking about only has Social Security income and that's all they have, you really, really don't need a guardianship of the estate. And that's because the Social Security Administration appoints people as representative payees. I bet at least 5 people on this call are already representative payees. And you don't need to be a guardian to be a representative payee. And you're already reporting to the Social Security Administration every year. You're reporting what you're spending, how you're spending it. So it's redundant to also be a guardian of the estate. And the judge I go in front of simply tells people she doesn't want to be reading guardian reports, because guardians have to file annual reports if the only thing on there is Social Security, right? Because it's just redundant. It's like a waste of the court's resources. So I consider this to be an alternative to guardianship, right? And it works really well if that's the only money that a person has. And to become a representative payee, you fill out the SSA 11 form. Has nothing to do with guardianship whatsoever. In fact, you can be a guardian and not be a rep payee, and vice versa. So there's that. You can't, these are just requirements about being a representative payee. You get investigated, but that happens if you apply to be a guardian too, right? You can't like just be like a random criminal, like who committed acts of dishonesty and now you're going to be a rep payee, but you can't do that and really be a guardian of the estate either. So, and they prefer someone who actually knows the person. An agency can be in rep payee, but that is a good alternative to guardian of the estate. Gerri talked about financial powers of attorney. She knows more about this than me. We don't do these at DRP. We always refer people out to attorneys to do these. You have to be, you know, she already discussed it. You have to know what you're signing. You have to be of sound mind to create a financial power of attorney and to have appoint an agent to manage your money. Now, the way the statute's written, it lists all the things that can be on a financial power of attorney, and it's like almost all financial, the things that you can put in there, but there are some clauses about like admitting to a nursing home and nursing home care. But generally speaking, the healthcare decisions are on a different form, a healthcare advance directive, or if some people call it a healthcare power of attorney. Again, I'm not a trust attorney, but when someone has large sums of money, or if they want their child to inherit large sums of money and they're like, well, they need a guardian because they're going to inherit all this money and they don't understand it. Well, I was advised them to call a trust attorney because they can set up a trust in a way that's an alternative to guardianship. The beneficiary, that could be the person with the disability, could have access to the money through a trustee, and the trustee could make all of the decisions the same way a guardian would, and you're avoiding guardianship. You're not filing every year with the court, but there's still oversight there because trusts do have some oversight. But you should definitely go to a trust attorney if you need a trust, and I'm not a trust attorney. Oh, you know what I don't have on here? I don't have the ABLE accounts. Are you guys familiar with ABLE accounts? They're kind of a good alternative to guardianship because if the person has even like the slightest capacity, they can sign over someone else to take care of the account for them. And ABLE accounts are like good for someone can deposit up to $15,000 a year into an ABLE account. So it's a good way to kind of manage extra money that might not be enough for a trust. And someone else can have oversight of that. Did you have something, Gerri?
No.
Oh,
Yeah.
I thought you were gonna say.
Well, what I was gonna say is I think we've done Allison, haven't we done a seminar or webinar on ABLE accounts?
Yeah, we had someone from the state treasurer's office.
Yeah.
But I think the word is not out all over about ABLE accounts. So
Yeah,
It's a great mechanism because it allows an individual who qualifies for Social Security due to a disability to still have additional amounts available to them.
yeah, and they still can retain their services, but they have more than the minimum because normally people have that very little amount in savings.
Yeah.
It allows them to have more, but it is easy for them to sign, the account over to someone else to manage. So if, they still need to be able to understand enough to do that, but just enough to do that. And then the other person can manage it on their behalf for them. Now I'm going to talk about a little bit about different alternatives to guardianship, which is like the doomsday scenario. Like sometimes people file for guardianship because they're really afraid something bad may happen in the future. And it's like, it hasn't happened yet, but they're like, what if this bad thing happens? Like what if my loved one gets scammed, or what if my loved one gets taken advantage of, or what if, blah, there's so many bad things that could happen, right? To all of us, not just people with disabilities. But I'm more of like a wait and see type person. Like the bad thing hasn't happened yet. And honestly, like the way I feel is when people have loved ones like that are so protective, it's very unlikely to happen because the loved ones are like making sure nothing bad happens. But if something bad were to happen, you know, there's agencies all over the state that can be called, right? There's adult protective services for people with disabilities, and for people over 60 or over, there's older adult protective services. And they can be contacted for lots of reasons. They can be contacted if someone is like abused or abandoned or taken advantage of, or if there's fraud, or if there's self-abuse or self-neglect. Like sometimes we see that with older people, they stop taking care of themselves. So it's kind of like, maybe give them a chance. Guardianship to me seems like overreach to try to prevent something from happening that you don't even know is going to ever happen. And you're taking away that person's ability to make decisions and grow because you're afraid, when there are protective agencies out there who can step in if something happens. The phone number is on the screen now. It's the same for all of the agencies that you would call if you suspect abuse or neglect or fraud or any kind of thing. And sometimes, adult protective services gets involved, and sometimes they do petition for guardianship, but because they think that's the only way to help. But sometimes there's other ways of helping, right? Sometimes the person needs monitoring, or they need service, or they need social work. They don't always necessarily need a guardian to correct the problem. There's like a whole investigation process that they go through to determine if there is a need. And if it's substantiated, it moves forward into protective services. It's assessed. I'm just buzzing through these slides. It's like what I'm talking about. So, when the reason for guardianship is because the person has a disability and you're afraid something may or may not happen in the future, I always encourage people to like be there, give them support, be their family, be their loved one. That bad thing you're afraid of might never even happen. And if it does, at that point, you can call protective services. So someone asked this question. So first of all, I did criminal defense work early on in my career. I could say that even if someone's incapacitated, that's not like an automatic get out of jail free card. So if you're like, oh, I'm afraid my loved one's going to get into trouble, so I'm going to become his guardian to protect him, might not protect them anyway. It's still a defense they have to put up, right? Like an incapacity defense, they have to put that up independently of the fact that you are their guardian. And then there's a rule of professional conduct, 1.14b. And the way I interpret this rule is that, like, let's say your loved one lacks capacity and they get arrested. Their lawyer, they're going to get a lawyer, right? It's America, they're going to get at least a court-appointed lawyer if they don't get a lawyer that you pay for. If the lawyer can see, or if you tell the lawyer, look, they don't have capacity, they're allowed to consult with you. They don't have to leave you in the dark. Like, you're allowed to know what's going on. You're allowed to talk to them. They can consult with you. You're the individual or entity that you can take action to protect the person. So I think sometimes there's a fear that, like, I guess the fear is someone's going to get arrested. And you're going to be shut out and you're not going to be able to help them. But the lawyer can consult with you. And just because you are their guardian doesn't mean it's like a get out of jail free card. It might make it easier for the like for the finder of fact, the jury or the judge, to say, like, oh, okay, this person is legally incapacitated, but it's not like an automatic defense.
If I could jump in, there's two questions in the chat. One asks if you can talk about the difference between doesn't make decisions I agree with and cannot make decisions.
Yeah, that's great. I'm sure Gerri will have something to say about this too, but like legally, when people are 18, they have the right to make their own decisions, and they have the right to make their own bad decisions. And unless a court deems them incapacitated and assigns a substitute decision maker, that's what a guardian is. they have the right to fail, and they have the right to make poor choices. And we call that in disability community the dignity of risk. It means like it's better to give someone the dignity of making a bad choice and failing than it is to make choices for them, because it's like part of growing and being a person and all that fun stuff that we all get to do, right? And when someone's 18, right, everyone who's 18 is making some bad choices, and that's like part of growing up. So just because they are doing something you might not agree with doesn't necessarily mean that they're incapacitated and that they need a guardian. And I'll let Gerri chime in.
I'm smiling because many, many years ago, when my grandmother was elderly and was insisting in staying in an apartment, probably beyond when it was really safe for her, my parents talked to her doctor and said, well, isn't she, doesn't she need a guardian? Can't we get her out of there? She's making such bad decisions. And the doctor said, she has the ability to make decisions. She's made a decision that you may think is a bad decision, but she's made a decision based upon what she wants and what she feels is best for her. So fast forward like 30 years, when I couldn't get my parents out of their 4-bedroom house in Mount Lebanon that they've been living in for 48 years, and it was like deja vu all over again. I kept reminding them of the fact that they wanted to get a guardian for my grandmother to remove her from the house because they thought she was making such a bad decision, and they had the same ability to make the same bad decision. It's okay. I mean, you're not going to agree with every decision everybody makes. Now, if it gets to the point where they truly are a risk for themselves or others, and not just I might fall down the steps, but I'm really not capable, I leave my stove on and I don't know how to turn it off, and I may blow up my house. There's degrees, but then again, there are other things you can do short of getting a guardian. Having the ability to make decisions includes having the ability to make decisions other people will disagree with.
Yeah, I agree with that. And I'd say, like, if your loved one is making dangerous decisions, I still think it's better to call adult protective services or older adult protective services, and they might decide to petition for guardianship, right? They might say, like, she really needs a guardian, she's going to hurt herself. But then it's not you, right? Because that could create a lot of contention within a family when one person is petitioning for guardianship against another person who doesn't want it.
That's what I end up spending half of my legal career fighting now is, family members. But the other thing is that there are situations where somebody makes such a bad decision. I had a case a couple of years ago where a woman came and her brother was in jail. He was schizophrenic. He wouldn't take his medication. He refused to let them administer medication. He became catatonic. First he was psychotic, then he was catatonic, and the jail insisted that the only way she could consent to his being administered medication against his will is if she were appointed guardian. I wonder what they would have done with that healthcare directive. I'm not sure the jail would have accepted that, but that was a situation where he didn't even have the ability to make a bad decision by that point. And it was a temporary guardianship because as soon as he got medication, he was doing much better and he was able to handle his criminal situation, and the guardianship was removed. It was temporary. So that's another thing. These guardianships don't have to be forever.
Yeah. One more question before we move on. Are there items that people with disabilities can carry to make sure or to prevent them from getting arrested? For example, if someone has a speech disorder and normally is not needing a guardian, but might not be able to communicate clearly.
No, that should exist, but I'm not aware of it. And it sounds like a good idea, though. People could make one up, right?
So in the autism community, I know there's a little card that I don't know which autism organization, at least in Pittsburgh area, has put out that you can carry with you to hand to an officer to explain why you're having sensory issues and not able to comply with the officer's instructions. But I don't really know how effective that is.
Yeah, there's actually a law that they're working on changing the laws right now. There's committees of people to make it so that officers are not the ones to respond to like 302 calls and stuff, because and that's kind of not really exactly what you talked about, but some of the problems when when officers respond, and if someone has a disability, either like a mental health disability or developmental disability, they don't know what to do. They're police, right? They're not therapists or social workers. So there's like they're working on that right now, but I don't know what the progress is. I'm not in that department where I work.
One more
Yeah.
question about, are there therapists specialized in working with families who want a guardianship?
That's a very interesting question. The answer is I don't think there are therapists who specialize in this. And I don't know that that's an area I mean, it's as much a legal issue as it is a therapeutic issue. And the way this is worded, families who want a guardianship, I'm not sure that should be the appropriate line of inquiry. I think it's really, is a guardianship needed, and is it in the best interests of everybody? But I don't know mental health. I mean, I know therapists and mental health professionals who do evaluations to see if someone has capacity under the legal standard, but not advising families on when it might or might not be appropriate to get a guardianship. What do you think, Elysia?
I mean, I agree. It's that's not the legal question. Like Gerri talked about at the beginning, the law says guardianship should only be imposed when it's necessary, when there's no less restrictive alternative. So I don't think the question should ever be, does the family want a guardianship? The question should always be, is a guardianship necessary? And to me, I feel like a guardianship is only necessary if you go through all the alternatives and they don't work. Can't sign a power of attorney, doesn't have capacity, can't do a healthcare representative because there's too much capacity and it looks, there's a conflict, like can't do this, can't do that. But I don't, all my clients are like people entering adulthood, like 18-year-olds who are facing guardianship, and I represent their right to not have a guardianship. And the parents always want it, right?
I guess, so I put that question in. I'm just wondering what like psychologically, for parents that are seeing a therapist, or for families that are seeing a therapist, or for an individual who's seeing a therapist, is this like a topic?
I think, from my opinion, the topic should be about control, because what I was going to say is my clients are 18-year-olds whose parents are filing for guardianships because they want control. And a lot of times it's almost never necessary. Like I said, I think 9 times out of 10, there's no guardian appointed because the parents are afraid. It's not coming from a bad place, but they're afraid to the point where the parents need help, right? They're so afraid.
But the conversation is more about what they need as far as being individuals, rather than if the guardianship were to happen.
When you say they, do you mean the parents or the children?
The children that you're working with.
Yeah, because it's like the parents are filing because it's what the parents need. The parents are like, I'm afraid. I feel like if I don't have guardianship over my kid, I'm going to have a panic attack.
Yeah.
Well, that's like their problem. It's like the kid hasn't done anything yet to prove that they need a guardian. And a lot of them have capacity. Like a lot of them have enough capacity to even sign the power of attorney. So it's like a control thing. And so when it comes to the family dynamic, sometimes I'm like, whatever fear the parents have, they have to understand also that there's resources for the child too. Like if a child gets a waiver, like either the autism waiver or the intellectual disability waiver or the consolidated waiver, those waivers are going to help that child learn skills to live in the community. And sometimes these parents haven't even applied for that waiver. And a lot of my thing in court is like, these parents should be using their energy to get these kids services, not apply for guardian, because someday they're going to be dead, right? And the kid needs to learn how to balance a checkbook and how to call the bank and how to go grocery shopping. And waivers will help a child with all that. Like if they get the right waiver, they'll have like a support aid, and they'll have people teaching them life skills, and they'll have a job coach. And that's really what a lot of kids need. They don't need their parents continuing to make decisions for them until they're 50 and then the parents die and the kid is like in the same situation they were in when they were 18. Because I'm court appointed guardian over people like that, whose parents became guardian when they were 18. Parents die when the kid is like 55, 60, and now the kid is like, has no life skills at all. So if I were to go off on a tangent, I'd say the better thing to do than seek guardianship is try to get your kid the skills that they need, especially if they have some capacity. Find them services, like find them places to live that are going to be supportive of them living independently, teach them independent living skills, teach them all this stuff, teach them social skills, because you making decisions for them for the rest of their life isn't going to help them when you're gone. I know it sounds really mean. I probably sound like a horrible, harsh person, but there is a point at the end when you're not going to be here, and you want them to be independent at that point. Anyway, sorry.
No, it's an important conversation or an important point for people to consider. We're coming up on the end of our time, and I just want to give you one last question. Are any of your clients nonverbal? What do you recommend in that scenario?
I've had several, they haven't been my clients. The parents have been my clients. I've worked on several guardianships with adult children who are nonverbal and have not been able to communicate, and have not been able to communicate in writing either, or through assisted communication devices. And if they really can't communicate, that's part of the test for capacity. Is receiving, evaluating information and communicating decisions in any way possible. And if someone cannot communicate, then I do think they meet the definition of the legal definition of incapacity. I don't know. I would think it's very hard to know what someone wants under those circumstances.
And those are the people that a healthcare representative works well for, right? Because they can't communicate. And then the parents can be healthcare representatives, although I normally encourage the parents also to have someone else in their life who's younger than them, like a sibling of the person who's nonverbal, to be involved in making these decisions, so that, again, when the parents are gone, that sibling can make the decisions. Because under that statute, it can be parents, but it can also be adult siblings. It can be a friend of the family. But yeah, communication is part of the incapacity test.
And I will tell you, I've also worked with families where adult children have been very relieved that their parents get to remain in the role that the parents have been in. And now maybe I see Elysia's point that they also need to learn the life skills to be independent, is because when something happens to their parents, that's going to be very difficult. But I've also seen the great relief with adult children in their 20s or late teens who wanted their parents to be able to, they wanted to be assured that their parents would continue to be able to do what they've been doing for them legally. So I think, again, there's not a one size fits all answer.
No, that's true. And I've had clients who have said, I want my parents to be guardian.
Yeah.
And then I have an easy case because I don't know. I'm just like, okay, I don't have to say anything. But most 18-year-olds want some independence. But I have had the ones who have said, no, I'm on board with my parents being a guardian. And then I do what my client wants and represent that to the court.
Okay, well, I think we've come to the end of our time, and I want to be sensitive to all of your schedules. I really want to thank Gerri and Elysia. This was a really interesting and complex subject, but I think all of us will leave tonight knowing more than when we came in. A lot of people have asked for forms and information, so I will communicate with both speakers, and when I send you the evaluation form, I'll have that information linked to it as well. So thank you all for spending your evening with us, and thank you, Elysia. Thank you, Gerri. This was great.
Aye.